Hello Year 12s and welcome to this video on the Victorian Law Reform Commission. There are 4 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. The third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. And the fourth thing you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you may be unfamiliar with. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out your learning intentions for the work that we're going to be doing on the Victorian Law Reform Commission. This work will involve you watching and taking notes on this video, as well as studying a recent example of a Victorian Law Reform Commission inquiry, which I'll be giving you in class. Make sure that you write these learning intentions down in your Cornell notes. As a result of watching and taking notes on this video and reading the example of the Victorian Law Reform Commission inquiry, which I'll give you in class, you should be able to do 3 things. First, describe the role of the Victorian Law Reform Commission and its ability to influence law reform. Second, describe one recent example of a Victorian Law Reform Commission inquiry relating to law reform in the civil or criminal justice system. And third, evaluate the ability of the Victorian Law Reform Commission to influence a change in the law using recent examples. In this video, I'll often refer to the Victorian Law Reform Commission as the VLRC. In answering a SAC or exam question, you can also refer to the VLRC, but only after you have first referred to it in your answer as the Victorian Law Reform Commission, that is, written out in full, open brackets, VLRC, close brackets. Finally, you'll see that our learning intentions refer to recent examples. When we refer to recent examples, we mean examples of Victorian Law Reform Commission inquiries from the past 4 years, which can include where a change to the law has been made to implement a VLRC inquiry recommendation, even if that VLRC inquiry finished more than 4 years ago. The Victorian Law Reform Commission is an independent, government-funded law reform body which is established by the Victorian Law Reform Commission Act of 2000. That's a Victorian Act. Look down the left-hand side of your vocabulary sheets, find the term Victorian Law Reform Commission and write this definition in there. Broadly speaking, the Victorian Attorney-General refers law reform matters to the Victorian Law Reform Commission to investigate. This is because the Victorian Government and the Victorian Parliament don't have the time or resources to thoroughly investigate all legal issues themselves. The Victorian Law Reform Commission then researches the law reform matters that have been referred to it and makes recommendations for changes in the law. It's important to remember that there is no requirement for the Victorian Law Reform Commission's recommendations to be implemented by either the Victorian Government or the Victorian Parliament. These are simply recommendations for changes in the law. On this slide, I've set out a number of mistakes that students frequently make about the Victorian Law Reform Commission. Make sure that you don't make these mistakes. First, the Victorian Law Reform Commission is not a court. It doesn't decide cases and it doesn't resolve disputes. Second, the Victorian Law Reform Commission is not a tribunal. Don't confuse the Victorian Law Reform Commission with the Victorian Civil and Administrative Tribunal, that is VCAT. Third, the Victorian Law Reform Commission is not a lawmaking body. As I've said, the Victorian Law Reform Commission only recommends changes to the law. It's entirely up to Parliament to decide whether or not to make a law that implements those recommendations of the Victorian Law Reform Commission. Fourth, the Victorian Law Reform Commission does not recommend changes to Commonwealth law or the law of any state except Victoria, and it only makes recommendations for changes to the law to the Victorian Parliament, not the Commonwealth Parliament or the Parliament of any other state. Remember, it's the Victorian Law Reform Commission. It only deals with changes to Victorian law, and it only makes recommendations for law reform to the Victorian Parliament. Fifth and finally, the Victorian Law Reform Commission is not a place where you can go for legal advice. Don't confuse the Victorian Law Reform Commission with Victoria Legal Aid, or VLA. You'll recall that our first learning intention requires you to be able to describe the role of the Victorian Law Reform Commission. On this slide, I've set out the four main roles of the VLRC. Make sure that you write each of these roles down in your summary books. The first and most important role of the VLRC is to make recommendations on law reform matters referred to the VLRC by the Victorian Attorney-General. When we talk about the Victorian Attorney-General referring a law reform matter to the VLRC for investigation, we mean that the Victorian Attorney-General sends terms of reference to the VLRC to investigate that law reform matter. The terms of reference set out the instructions to the VLRC about the specific matters that the Victorian Attorney-General wants the VLRC to investigate and to make recommendations about. The terms of reference will also specify the date by which the VLRC must provide its recommendations about that law reform matter to the Victorian Attorney-General. Look down the left-hand side of your vocabulary sheets, find the phrase terms of reference and write this definition in there. When you're writing an answer to a SAC or exam question, please describe law reform matters as being referred by the Victorian Attorney-General to the VLRC for investigation, rather than as being sent by the Victorian Attorney-General to the VLRC for investigation. This is because refer is the more appropriate legal term. The second role of the VLRC is to make recommendations to the Victorian Attorney-General on minor legal issues of general community concern. You need to remember this phrase. This refers to law reform matters that the VLRC can investigate without using up lots of time and resources, but that are nevertheless important to the community. For example, a little while ago, the VLRC investigated how the law should be changed to give effect to the wishes of people who have died in relation to the disposal of their bodies. For instance, how to ensure that a dead person's wish to be cremated rather than buried was obeyed by the deceased's relatives. This was a relatively minor legal issue, but it's one that affects a large cross-section of the community, as we all have to die sometime. The VLRC does not need to receive terms of reference from the Victorian Attorney-General to investigate minor legal issues of general community concern. Instead, it can do this without any such referral. Often, a VLRC investigation into a minor legal issue of general community concern will be initiated by the VLRC because that matter has been raised with the VLRC by members of the public. The third role of the VLRC is to suggest to the Victorian Attorney-General that the Victorian Attorney-General should refer a law reform matter to the VLRC for investigation. This is the way in which the VLRC can bring law reform matters to the attention of the Victorian Attorney-General. It's then up to the Victorian Attorney-General to decide whether to refer the law reform matter to the VLRC so that the VLRC can investigate it. And the fourth and final role of the VLRC is to educate the community about the VLRC's work, including by VLRC staff visiting schools and explaining to students what the VLRC does. Now, a very important part of the VLRC's role in recommending law reforms is to consult widely about any proposed law reforms. This is something that we'll be looking at in more detail in the next slide. On this slide, I've set out the process that the VLRC uses to investigate a law reform matter. Please include a copy of this diagram in your summary books. You'll see that there are 5 main steps in this process. The first step is that the Victorian Attorney-General refers a law reform matter to the VLRC for investigation. As I've explained, this means that the Victorian Attorney-General provides the VLRC with terms of reference to investigate that law reform matter. These terms of reference set out the specific matters that the Victorian Attorney-General wants the VLRC to investigate and make recommendations about, together with the date by which the VLRC must provide its recommendations to the Victorian Attorney-General. As I've also explained, this step does not apply where the VLRC is investigating a minor legal issue of general community concern, because the VLRC can investigate these kinds of issues without a reference from the Victorian Attorney-General. The second step in the VLRC process is that the VLRC undertakes some initial, that is preliminary, research into the law reform matter. This will often involve the VLRC consulting with experts to identify important issues. VLRC staff are legal experts, not subject matter experts, and this is the reason they will often need to consult with subject matter experts. For example, in 2014, the Victorian Attorney-General announced that the Victorian government intended to legalise medicinal cannabis for people in exceptional circumstances and asked the VLRC to report on options for how this could be done. The VLRC needed to consult with medical experts about this. The third step in the VLRC process is that the VLRC publishes a consultation paper, sometimes called an issues paper. The purpose of this paper is to explain the key issues that are relevant to the law reform matter and to ask questions that the VLRC wants to have answered so that it can make recommendations about the law reform matter. You'll remember that I said that a very important part of the VLRC's role in recommending law reforms is to consult widely about any proposed law reform. Well, this is the purpose of the consultation paper. The consultation paper invites submissions from the public and other interested groups about the law reform matter. These are written submissions which must be sent to the VLRC by a date specified in the consultation paper, and the VLRC will read, consider and take all of these submissions into account when it's formulating its recommendations for law reform. The fourth step in the VLRC process is also focused on consultation. Not only does the VLRC invite written submissions from the public and other interested groups on the law reform matter that it's investigating, but the VLRC will also hold public forums and roundtable discussions where the VLRC meets with members of the public and other people with a particular interest in the law reform matter. At these meetings, the VLRC will outline issues associated with the law reform matter, and the people at the meeting will be given a chance to explain their views about those issues. Again, the VLRC will consider and take all of these views into account when it's formulating its recommendations for law reform. Now, sometimes, but not always, the VLRC will then engage experts to research additional matters relating to the law reform matter that the VLRC is investigating. And sometimes, but not always, the VLRC might publish an interim report. That is, a draft report that sets out the recommendations on the law reform matter that the VLRC is proposing to make. If the VLRC publishes an interim report, then the VLRC will also consult on the draft recommendations in that report, including through inviting more written submissions and having more face-to-face meetings with interested parties. Whether or not the VLRC engages experts to do additional research, and whether or not the VLRC publishes an interim report, the fifth step in the VLRC process is that the VLRC delivers its final report, which contains its recommendations for changes in the law, to the Victorian Attorney-General. This is the end of the VLRC's investigation into the law reform matter. Once the VLRC's final report has been delivered to the Victorian Attorney-General, the Victorian Attorney-General must table the VLRC's report in the Victorian Parliament. At that time, the VLRC's report is also made available to the public, including by being published on the VLRC's website. As I've said, the role of the VLRC is to make recommendations about changes to the law. It's then up to the Victorian government whether it wants to proceed with those changes by introducing a bill into the Victorian Parliament that implements those changes. And if the Victorian government does this, it's then up to the Victorian Parliament to decide whether to pass, amend or reject that bill. The VLRC plays no role in this process. Our second learning intention requires you to be able to describe one recent example of a Victorian Law Reform Commission inquiry relating to law reform in the civil or criminal justice system. To enable you to fulfill this learning intention, we will be looking in class at an example of a recent VLRC inquiry into such a law reform matter, including the influence that the VLRC had on changing the law through its recommendations about that law reform matter. Our third learning intention requires you to be able to evaluate the ability of the VLRC to influence a change in the law using recent examples. The next few slides respond to this learning intention by setting out a table which describes both the strengths and the weaknesses of the VLRC in influencing law reform. You should use the information in this table to help you evaluate the ability of the VLRC to influence a change in the law, which is the focus of this third learning intention. Please include a copy of this table in your summary books and make sure that you supplement the information contained in this table with notes from your reading of the textbook and from the discussion which follows, which will help you to better explain the points made in this table. The first strength of the VLRC in influencing law reform is that the VLRC can assess community views about the law reform matter that it is investigating by inviting written submissions from the public and other interested people, and by holding meetings with the public and other interested people about the law reform matter. As I've explained, the VLRC informs itself of the views of the public and other interested people about a law reform matter by inviting written submissions from them in response to a consultation paper and by holding public forums and roundtable discussions at which the public and other interested people can express their views about the law reform matter. This extensive consultation helps ensure that any recommendations that the VLRC makes for changing the law meet the needs of the Victorian community. And the fact that the VLRC undertakes consultations on a law reform matter before making its recommendations for changes to the law can give the Victorian Parliament confidence that those recommendations reflect the Victorian community's views on that law reform matter. This in turn means that the Victorian Parliament is more likely to pass legislation to implement the VLRC's recommendations. The second strength of the VLRC in influencing law reform is that the VLRC is able to comprehensively investigate a law reform matter. As I've said at the beginning of this video, one of the reasons that the Victorian Attorney-General will refer law reform matters to the VLRC to investigate is because the Victorian Government and the Victorian Parliament don't have the time or resources to thoroughly investigate all legal issues. This is something that the VLRC is well equipped to do because it specialises in investigating law reform matters. As a result, the Victorian Parliament can have confidence that, in investigating a law reform matter and making recommendations for changes to the law, the VLRC has thoroughly investigated that law reform matter, together with the advantages and disadvantages of any change to the law. It's then up to the Victorian Government to initiate a new law to reform the law by introducing into the Victorian Parliament a bill that makes changes to the existing law. Importantly, the fact that the VLRC's recommendations for law reform are based on a thorough investigation of the law reform matter means that the Victorian Parliament is more likely to pass legislation to implement the VLRC's recommendations. However, while the VLRC undertakes extensive consultation on a law reform matter and comprehensively investigates that law reform matter, its investigations can be time-consuming and therefore very costly. The VLRC does not have endless resources in terms of time and money to spend on investigations, and so there may be a limit on the resources that the VLRC can devote to investigating a particular law reform matter. In addition, the scope of the VLRC's investigations into a law reform matter might be limited by the Victorian Attorney-General's terms of reference. The VLRC can't investigate any aspects of a law reform matter that it's not instructed to investigate under the Victorian Attorney-General's terms of reference. In other words, the extent of the VLRC's investigation into a law reform matter can be limited both by the resources that the VLRC has available to it and by the terms of reference that the Victorian Attorney-General gives to the VLRC. The third strength of the VLRC in influencing law reform is that the VLRC is independent of both the Victorian Government and the Victorian Parliament. Accordingly, its recommendations are objective and unbiased. This is an advantage because it means that the Victorian Parliament is likely to give significant weight to the VLRC's recommendations. In particular, the Victorian opposition is more likely to vote in favour of any bill that is introduced into the Victorian Parliament to implement the VLRC's recommendations to change the law. This in turn means that the Victorian Parliament is more likely to pass legislation to implement the VLRC's recommendations. Indeed, statistics demonstrate that the Victorian Parliament is significantly influenced to change the law, that is, to make law reform, by the VLRC, largely because the Victorian Parliament recognises that the VLRC thoroughly investigates law reform matters, extensively consults on any law reforms that it recommends, and is an expert and independent law reform body. The significant influence that the VLRC has in law reform is shown by the fact that the Victorian Parliament has passed legislation to implement all or some of the VLRC's recommendations on law reform in approximately 75% of all law reform investigations conducted by the VLRC. Having said this, a significant limitation on the ability of the VLRC to influence law reform is that there is no guarantee that the VLRC's recommendations for law reform will be implemented by changing the law. The VLRC itself cannot change the law. Instead, it's entirely up to the Victorian government as to whether it introduces into the Victorian Parliament a bill to change the law as recommended by the VLRC. And it is entirely up to the Victorian Parliament as to whether it passes, amends or rejects that bill. In short, there is no obligation on the Victorian government to support the VLRC's recommendations, and there is no obligation on the Victorian Parliament to pass legislation that implements the VLRC's recommendations. The fourth strength of the VLRC in influencing law reform is that because the Victorian government, acting through the Victorian Attorney General, generally has to refer an issue to the VLRC for investigation, it is more likely that the Victorian government will act on the VLRC's recommendations for a change in the law regarding that issue. There'd be little point in the Victorian government referring a law reform matter to the VLRC for investigation if the Victorian government was not prepared to act on the VLRC's recommendations by introducing a bill into the Victorian Parliament to change the existing law. However, the Victorian government is not in any way bound to support the VLRC's recommendations, which means that it does not have to introduce a bill into the Victorian Parliament that changes the law in accordance with the VLRC's recommendations. In any event, as I've said, even if the Victorian government does introduce into the Victorian Parliament a bill that changes the law in accordance with the VLRC's recommendations, the Victorian Parliament can still reject that bill. Accordingly, this strength is very much just a minor strength of the VLRC in influencing law reform. The final strength of the VLRC in influencing law reform is that the VLRC does not need a reference from the Victorian Attorney General to investigate and make recommendations about minor legal issues of general community concern. This is important because it means that the VLRC can investigate and make recommendations about such issues where the VLRC identifies a need to do this. In this way, the VLRC can help ensure that Victorian laws are updated and improved because the Victorian government and the Victorian Parliament might not even be aware of the need to change the law. Now, don't forget that the role of the VLRC is simply to recommend changes to the law. It is entirely up to the Victorian government and the Victorian Parliament as to whether those changes are actually implemented. I've already given you an example of a minor legal issue of general community concern that the VLRC has investigated and made recommendations about. This was the need to change the law to enable the enforcement of the wishes of deceased people regarding the disposal of their body after death. The VLRC's recommendations were intended to update and improve the law by ensuring that the wishes of deceased people about the disposal of their body are obeyed by their relatives. However, ultimately the Victorian government decided not to support these recommendations, and so Parliament did not end up making a law that implemented the reforms proposed by the VLRC. On the other hand, the ability of the VLRC to recommend law reforms is limited to some extent. Except for minor legal issues of general community concern, the VLRC cannot investigate and make recommendations on a law reform matter unless that law reform matter has been referred to it by the Victorian Attorney General. Put another way, unless the Victorian Attorney General has referred a law reform matter to the VLRC for investigation by giving the VLRC terms of reference to investigate that matter, then the VLRC is not able to influence law reform through investigating that law reform matter and making recommendations about changes to the law. Well, that brings us to the end of this video. As a result of watching and taking notes on this video and reading the example of the Victorian Law Reform Commission inquiry, which I'll give you in class, you should be able to do three things. First, describe the role of the Victorian Law Reform Commission and its ability to influence law reform. Second, describe one recent example of a Victorian Law Reform Commission inquiry relating to law reform in the civil or criminal justice system. And third, evaluate the ability of the Victorian Law Reform Commission to influence a change in the law using recent examples. Don't forget to read the pages from the textbook referred to on the first slide of this video. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.